arbitrator for domestic and international. To appoint the arbitrators, we can refer in Section 13 of Arbitration Act 2005. First of all, we should know that the parties are free to determine the number of arbitrators. In Section 12, if there is no agreement, the tribunal shall in the case of international arbitration consist of 3 arbitrators, and a sole arbitrator for the domestic arbitration. In Section 13, the arbitrator may be of any nationality and the parties may agree the appointment of the arbitrator.
In the domestic arbitration, the party itself have to agree to appoint the single arbitrator, or if within 30 days the parties still not reach an agreement to appoint, any party may request for the single arbitrator to be appointed by director. For appointment of international arbitrator, if the party have agreed that 3 arbitrators are to be appointed, each party shall appoint 1 arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator as the preceding arbitrator. Either of party can request the other in writing to appoint an arbitrator, and the arbitrators should do so within 30 days of their appointment. If a party failed to appoint an arbitrator within 30 days of receipt of a request, or the 2 arbitrators fail to agree on the 3rd arbitrator within 30 days or such extended period as the party may agree, either party may apply to the Director of KLRC for arbitration for such appointment. Next, about the existence of agreement, where the parties have agreed on the procedure for appointment, but a party failed to act as required under such procedure. For example, the party failed to appoint nationality of arbitrator that already stated in agreement. Secondly, the parties or 2 arbitrators are unable to reach an agreement under such procedure, or a third party including an institution failed to perform any function entrusted to it under such procedure. Any party may request the Director of KLRC to take the necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment. In court jurisdiction, when KLRC failed to act, where the Director of the KLRC is unable to act or fail to act within 30 days from the request, any party may apply to the High Court for such appointment, because High Court is the last option for the parties to request appointment of the arbitrator. For the appeal, no appeal shall lie against any decision of the Director of the KLRC for arbitration by the High Court under this section.
The arbitrator owns a statutory duty to disclose any circumstances likely to give rise to justifiable doubts as to his impartiality or independence under Section 14(1) of the Act. The circumstances which can raise an issue as to impartiality, among others, are that the arbitrator is engaged in personal, business or professional relationship with one party to a dispute, or that he has an interest in the outcome of the dispute. As such, the issues as to the impartiality or independence of an arbitrator is one of the grounds to challenge the appointment of an arbitrator. To bring such challenge, parties must be able to show justifiable doubts as to the impartiality or independence of the arbitrator. Apart from this, an arbitrator's appointment can be challenged if the arbitrator does not possess the qualifications agreed to by the parties. Are there provisions of law governing the challenge or removal of arbitrators?
Yes. There are sections 14 until 17 of the Act govern challenges to, and removal of, arbitrators. An arbitrator may be challenged only if the circumstances give rise to justifiable doubts as to his or her impartiality or independence, or he or she does not possess qualifications agreed to by the parties.
Unless otherwise agreed by the parties, the party who intends to challenge an arbitrator shall, within 15 days after becoming aware of the constitution of the arbitral tribunal or of any reasons referred to in Section 14(3), send a written statement of the reasons for the challenge to the arbitral tribunal. The words, unless otherwise agreed by the parties in Section 15(1), signify that the parties can agree to a procedure for the challenge of arbitrator. Most rules of arbitration maintained by the arbitral institution set out their respective challenge procedures. The tribunal shall then make a decision on the challenge, unless the challenged arbitrator withdraws from office or the other party agrees to the challenge. If the challenge is not successful, the challenging party may, within 30 days after having received notice of the decision rejecting the challenge, apply to the High Court to make a decision on the challenge. The decision of the High Court shall be final and no appeal may be made.
If the challenge is successful, it appears that the other party does not have a right to appeal to the High Court against the decision. Where an arbitrator becomes in law or in fact unable to perform the functions of that office, or for any other reason fails to act without undue delay, that arbitrator's mandate terminates on withdrawal from office or if the parties agree on the termination. If any party disagrees on the termination, either party may apply to the High Court to decide on such termination and no appeal shall lie against the decision of the High Court. Where an arbitrator withdraws from office or a party agrees to the termination of the mandate of an arbitrator, it shall not imply acceptance of the validity of any of the following grounds. The circumstances give rise to justifiable doubts as to that arbitrator's impartiality or independence. The arbitrator does not possess qualifications agreed to by the parties. The arbitrator is in law or in fact unable to perform the functions of that office, or for other reasons fails to act without undue delay. A substitute arbitrator shall be appointed where the mandate of an arbitrator terminates, an arbitrator withdraws from office for any other reason, the mandate of the arbitrator is revoked by agreement of the parties or in any other case of termination of mandate. Where a single or the presiding arbitrator is replaced, any hearings previously held shall be repeated before the substitute arbitrator. Where an arbitrator other than a single or the presiding arbitrator is replaced, any hearings previously held may be repeated at the discretion of the arbitral tribunal.
For the avoidance of any doubt, any order or ruling made by the arbitral tribunal prior to the replacement of an arbitrator shall not be invalid solely on the ground that there has been a change in the composition of the arbitral tribunal.
Hachu. Do you know what the procedure of arbitration? After the arbitrators has been appointed, it will come to the stage, conduct of arbitral proceedings. Arbitration proceedings in Malaysia are governed by the Arbitration Act 1952 and the Arbitration Act 2005, the 2005 Act, which came into force on March 15, 2006. The parties can decide on any of the following such as determination of procedure, seat of arbitration, time for commencement of arbitral proceedings, language, hearings, appointment of expert. It can be one or more hearing depend on the issues at stake. The arbitrator shall disclose any circumstances that are likely to arise the doubts as to that person's impartiality or independence. The arbitral tribunal will justify all document and evidences provided by the party without any bias and prejudice. During the procedure of arbitration, the parties shall be treated with equality to present its case. The arbitral tribunal will justify all document and evidences provided by the party without any bias and prejudice. All the facts should be supporting with the claim. Then, they will obtain the arbitral award in writing. So-called arbitration agreement and signed by the arbitrator. If the arbitral proceedings involve more than one arbitrator, especially international arbitration, the signatures of the majority of all members shall be sufficient. An award shall state its date and seat of arbitration. The duty of tribunal to give reason for the remaining arbitrators did not sign the award. The copy of award will deliver to each parties. The applicant can make an appeal to High Court within 90 days of receive the arbitral award. The parties may challenge the arbitrator's jurisdiction whether partially or wholly. A total challenge occurs when it is contended that the arbitrator has no jurisdiction to determine any of the claims or counterclaims which have been submitted to it. The parties intend to challenge, within 15 days shall send a written statement of the reasons for the challenge to the arbitral tribunal. Unless challenged, make withdrawals from office by arbitrator or other party agree upon challenge. Arbitral tribunal shall make a decision on the challenge. If the challenge not successful, within 30 days after received notice rejected challenge party may apply to the High Court to make a decision on the challenge. The arbitral tribunal may continue the arbitral proceedings and make an award until the application pending ended. So, it can be summarized that the procedure of arbitration include: request for arbitration, appointed the arbitrator, preliminary meeting, hearings, discoveries of evidences, closure, and making award.
Conclusion: arbitration is a kind of method for the both parties through internal discussion without court involvement, which is can saving money and benefit to both parties.